Hello, my name is Michael Tesoro and I prepared this video presentation entitled AER Faces Hardsell on Origin Hardship Penalty Outcome, and it's about the recent case of AER and Origin Energy which came out in June 2022. The reason I've described it this way is because the AER is really going to struggle to convince anybody that this is a good outcome, given how poor the conduct was that was engaged in by Origin Energy. I think it won't achieve any specific or general deterrence. Bit of background about myself. I'm a competition and consumer lawyer. I've been running my own practice as AER Consulting for the last 14 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including in enforcement and mergers and asset sales. Outline of the presentation, pretty simple. Start with a bit of background, then look at Moshinsky's judgment, then look at the retailer authorization issue, which I think is an important issue, and then finish with some commentary. Now, strangely, the background to the case is actually an AER media release, which came out a couple of weeks before the judgment was released. And in that media release, I remember reading it and thinking this was very, very poor conduct, and I couldn't understand how a penalty of $17 million had been imposed. A number of Origin companies that engaged in breaches of the retail law and retail rules in relation to the way they implemented their hardship policies. And then in paragraph 3, you see that they implemented an automated process in relation to customers experiencing hardship and payment difficulties, and that they'd actually breached their hardship obligations on more than 100,000 occasions over a period of 4 years and had impacted 90,000 customers. It was also conduct which occurred, they say 4 states, but I think you can see there's 3 states and 1 territory. So this is sounding like very, very poor conduct, and immediately you're wondering how a $17 million fine is appropriate in that case. The AER goes on to say that the Origin Energy's automated system applied an inflexible process across thousands of customers, and they acted in complete disregard of their hardship obligations and breach of the law. That furthermore, they noted that people were distressed enough from being unable to pay for their electricity, and that implementing this particular process made it even more distressing as they're pushing people towards debt collection and disconnection. And then further, a recognition that the current market conditions were such that customers were facing significant cost of living pressures, including as a result of the recent energy price rises. But the thing that seems to be missing there is this happened during a COVID pandemic where people are under a lot of financial stress. So why the AER wouldn't have mentioned the fact that a lot of these vulnerable consumers were being impacted at a time during a COVID pandemic is quite beyond me. So the parties to the litigation are listed there, a number of Origin subsidiaries. And the conduct, as I said, related to their hardship provisions. Effectively, they had this Power On program, which was an implementation of their hardship policies, which seeks to identify customers who are having difficulty paying due to economic hardship, also how they're going to be entered into this particular program, and then finally how payment plans are going to be established and implemented. Now, the judge identified 3 separate courses of conduct. The first was an automated entry into new payment plans with increased instalment amounts. Secondly, the entry into a second payment plan without regard to capacity to pay. And then thirdly, automated cancellation of plans for non-engagement. So looking at each of those 3 in turn, starting with the first one, what occurred here was Origin would use its automated system to review the payment plans of its customers under the program. And if the program determined they were too low, it would automatically determine to increase the plan to a threshold amount. This was communicated to the consumer through SMS and phone call, but if the consumer had not responded to Origin within 3 days, then their payment plan was automatically cancelled and a new plan introduced at the higher level. And this conduct occurred over a 2-year period and impacted over 4,000 consumers on 4,500 occasions. The second course of conduct involved this automated system reviewing hardship plans and identifying those consumers who hadn't paid at least 90% of their instalment amount within 4 days of the instalment date. And so what the system did was it automatically cancelled the consumer's payment plan. Now, there was a little bit of light at the end of the tunnel here, because if it was the customer's first plan that had been cancelled for non-payment in the preceding 12 months and the plan was reinstated. But for all the other customers, their payment plans were automatically cancelled because they hadn't been able to pay more than 90% of the instalment within 4 days of the due date. And that conduct occurred for a 4-year period from 18 to 21, affected 87,000 customers on 105,000 separate occasions, and led to 43 customers having their electricity disconnected. The final one was further automated reviews of the hardship customers' usage and making sure they were paying an instalment amount that was above a threshold amount. Now, the customer had within 10 days of being contacted by Origin to respond, and if they didn't engage within that particular date, they had the payment plan cancelled and they were effectively thrown out of the Power On program, out of the hardship program. And this was happening despite the fact that customers are continuing to make payments under their plan. So just throwing out all these people from the plan. And this occurred to 11,000 customers on 12,000 instances, resulting in 23 disconnections, and occurred for a 2-year period. Now, the conduct just described is very serious conduct and breaches a number of provisions. The provisions are listed there. You've got 2 provisions of the retail laws and a number of breaches of the retail rules. And when you add up all those separate instances of breaches, there are at least 123,000 breaches of the retail laws and the retail rules. Now, when trying to set a penalty, you've got to be aware that the penalty provision, the way it was calculated, changed during the period. So up until January 28, 2021, it was the old system, which is $100,000 per breach, plus an amount of $10,000 a day for every day the breach continued. But then on the 29th of January 2021, it went to the more widely known penalty provisions that apply in the Competition and Consumer Act, which is $10 million, 3 times the benefit, 10% of turnover, whichever is the highest. Now, Moshinsky looked at all this information and he did conclude, and I don't quite know why, that the 10% of annual turnover measure should apply, and that seemed to be common ground between the parties. Doesn't make much sense to me, because the vast majority of conduct occurred under the old penalty regime and not the new penalty regime. So it seemed to me that what should have happened was that the old conduct should have been subject to the old penalty regime and the new conduct should have been subject to the 10% of turnover regime. I think potentially maybe AER and the Origin Energy believed it was just simpler to use the 10% of annual turnover test rather than do all the mathematics that would have been required to multiply out all the breaches that had been engaged in, including the $10,000 a day penalty, which could have been astronomical. So then Moshinsky goes on and says, on the basis of the 10% of turnover figure, which there you can see the turnover of Origin Energy Group during the period was $14 billion, that the maximum penalty would have been $1.4 billion. Now, at that stage, I'm thinking he's going to conclude that there's 3 courses of conduct, $1.4 billion, meaning the maximum penalty of $4.2 billion. And that's his starting point. But that's not the way it worked out. Rather, what Moshinsky said, that it's established law that when there's a very large number of contraventions involved, the maximum penalty may rise to a number such that there is no meaningful maximum penalty. So it's almost like saying, because the numbers are so huge, because the company has engaged in so many breaches of the law, that it's just pointless. So let's throw the whole idea out the window and use some other measure. I really don't understand that at all, unless he was thinking of applying 1.4 billion by 100,000 contraventions. Surely 3 courses of conduct times 1.4 billion arrives at a very large penalty, but a penalty that can be used as a worthwhile starting point. The thing I also don't understand is how ACCC v. Reckitt Benckiser stands in relation to the Macarian case, which is a High Court case, which makes it very clear that when working out civil penalties, the courts are expected to try and work out what the maximum penalty is that has been set by the legislature. So I think there's a little bit of inconsistency between those two decisions. Now, the penalties that were imposed by the court was $17 million, and the question is, how were they arrived at? Given that the 10% of turnover measure seems to have been thrown out as a worthwhile guide. Well, really there is no guidance in the judgment as to how this $17 million was arrived at. It really just appears at the end of the case as a acceptable penalty to the court. So what I tried to do is look at what this penalty actually represents. Say we had used the old penalty regime and multiplied 100,000 by 123,000 contraventions, we would have arrived at a penalty of $12 billion. And then if we look at the actual penalty of $17 million, then we can work out what percentage of the total maximum penalty the 17 million represents. And as you can see there, once you do all that mathematics, the penalty is a whopping 0.13% of the maximum potential penalty. Now that's even overstating it, because that doesn't take into consideration the $10,000 a day penalties, which would have also been applicable to all these breaches. Another approach you could have taken was just to look at Origin Energy's group revenue, which is $14 billion, and worked out the $17 million as a proportion of that. Well, that simple mathematics results in a penalty of 0.12%. So Origin Energy has been fined 0.12% of its annual group turnover for these contraventions. Again, these numbers don't seem to be the types of numbers that are going to achieve any specific or general deterrence. Furthermore, they seem a very far way away from what the legislature has said, which is 10% of turnover is the number that you should be looking at in relation to breaches of the law. I think the other thing that's key here is the Pattinson case, which is a High Court decision not long ago, which basically looked at when the maximum penalty should be imposed. And what they made very clear was that the purpose of civil pecuniary penalties is to promote the public interest in compliance by achieving deterrence. So key thing to look at there is the individual company engaged in the conduct, the breaches that they may have engaged in the past, the penalties they've been subject to, and whether those penalties have actually had the effect of achieving compliance, achieving deterrence. If they haven't, then a bigger penalty needs to be imposed. And that's what happened in relation to CFMMEU. They've been fined numerous times, hundreds of times for breach of the law. They continued to breach the law with impunity. Therefore, the maximum penalty had to be imposed to achieve the object of civil penalty provisions. Now, the question is, was that achieved in this case? And I will get to that in a couple of minutes. The first thing is a number of very strange omissions. The first strange omission is there was really no evidence before the court as to what caused this breach of the law, these thousands of breaches of the law. The judge actually comments that there was no evidence before him which explained how the breaches had arisen. He actually asked for further evidence, which was apparently provided, and then he was given this particular evidence to sort of explain. As you can see, Mr. Briskin, Executive General Manager Retail at Origin, said
Despite his belief that the automated system was compliant with the law, for reasons outlined in his affidavit, it is now my view that Origin did not have sufficient regard to its obligation under the retail laws. Now, that doesn't make any sense to me whatsoever. I don't think it made any sense to the judge. But this is the kind of pathetic evidence that's been put to the court to explain how the conduct arose. And this is where the AER has an obligation to fully apprise the court as to the circumstances that resulted in these very large number of breaches of the law. Another big omission in the particular case was the reference to Origin Energy's compliance record. And as you can see, I've listed all the different compliance breaches engaged in by Origin Energy as it relates to AER. You got 2022, they get in trouble for breaching metering rules. 2020, it's subject to 6 infringement notices for breaching the rules. 2019, Corner Forceful Undertaking for de-energising 54 small customers' premises. 2019, another 6 infringement notices for breaching the rules. 17, $40,000 in penalties for alleged wrongful disconnection. 2017, another infringement notice. 2017, 2 further infringement notices for breaching the retail law. 2016, a breach of the retail laws. So here you've got all these penalties being paid by Origin over the years for breaching the retail law and the retail rules. But this is not all they've been breaching. They've been breaching other provisions of the law as well. For example, breaching in 2021 Queensland Competition Authority reimbursement obligations, essential services, disconnection warnings, ACCC, alleged misleading deceptive conduct, 2019 New South Wales EPA, dust emissions, 2018, another breach in incorrectly calculating undercharge recovery rates, 2016, penalty for failure to follow dispatchal instructions, 2015, pay $2 million to the ACCC or as a result of ACCC action for unlawful door-to-door sales. And then furthermore, 2014, $8.3 million penalty for a long-term hardcore cartel in the Sydney forklift gas market. So this is a lot of breach of the law over many years. For what appears in the agreed statement of facts, this basically 2-paragraph statement of prior, similar or relevant conduct, and this is agreed with the AER, and effectively they're saying that we have not previously been found to breach the retail laws or retail rules in respect of obligations to customers who are experiencing payment difficulties. So they've narrowed the conduct very, very specifically and said, well, we haven't breached that particular obligation. And they mentioned 2 of the previous cases involving AER, leaving all the rest out. And Moshinsky doesn't even discuss the previous compliance record of Origin in his decision at all. This only appears in the agreed statement of facts. So there's a total glossing over of the terrible compliance record of Origin Energy. Then another strange omission, whether the conduct was intentional or deliberate. There's no reference in the judgment whatsoever. Clearly that's an important element of any penalty judgment. Was the conduct intentional or deliberate? Clearly reading the AER's press release, you'd assume that it was deliberate. This is the only reference to this issue in the whole judgment, which is in the agreed statement of facts. Origin's breaches of the retail laws were not deliberate, although the process of automating Origin's system obviously was. Now, what does that actually mean? I don't really know either. Clearly, you're setting up various functions of an automated system which are going to breach the retail laws, clearly breach the retail laws, kicking vulnerable consumers out of the system. This had to be deliberate conduct. Another strange omission, no reference to whether the conduct was engaged in by senior management. Moshinsky doesn't deal with that issue whatsoever. However, as you can see from the Green Statement of Facts, it was engaged by very senior people. The introduction of the automated system was overseen by its Retail Transformation Committee. It included Executive General Manager Retail, sounds like the person, Mr. Briskin, General Manager Customer Care, Group Manager Credit Risk and Fraud. So it did occur at the senior level of the business. But again, no discussion of that factor in arriving at the penalty. So the conclusion Moshinsky reaches is the contraventions are serious, occurred over a lengthy period of time, and accordingly $17 million is fine. No reference to the fact that they're vulnerable consumers, that's happening during the context of COVID, that it's engaging by senior management, that there's a terrible record of compliance of Origin, not only of AER rules, but generally compliance of various laws. No reference to any of that whatsoever in the judgment. Now, there's another very important issue here is relates to retailer authorisations. And as people may know, the AER approves companies to be retailers, energy retailers in both electricity and gas. And one of the requirements of being an approved retailer is that the person, or in this case the corporation, is of good fame and character, that they effectively meet the character or have the character or reputation to hold that particular role. So it's a fit and proper test. And AER has to satisfy itself that a company meets this obligation before being approved. Needless to say, Origin has been approved as both a gas and electricity retailer. Now, when they're looking at whether somebody is a fit and proper person or a fit and proper company, they look to see if the company has had a material failure to comply with regulatory requirements, laws and obligations over the previous 10 years, including infringement notices and other enforcement action. So by my count, this is about the 17th enforcement action against Origin in the last 8 years, so in the 10-year period, and yet they still remain a fit and proper person to hold a electricity and gas license. So looking at this case, it is quite remarkable, I think. I don't think the decision was right. Clearly, you're looking at extensive, long-running, serious conduct impacting vulnerable consumers over a COVID pandemic in breach of Origin's own internal policies that was engaged in by its senior management, by a company with an appalling compliance record, in some terms one of the worst compliance records I've ever seen of a large corporation, and they're fined $17 million on the belief that that is going to achieve specific general deterrence. Clearly the decision was wrong. It's not going to achieve any specific general deterrence, and why the AER is selling these really sound, strong, important cases so short is a big concern. Now, should the court have rejected the settlement? Well, yes and no. If the court had been fully apprised of all the relevant factors, then I'm sure it would have rejected the settlement. Judge Moshinsky is a great judge, and he has handled a lot of cases in relation to penalties very, very capably. However, here it just appears to me that he was not provided the information that he required to understand what was going on. In actual fact, a lot of the evidence that was put before the court seemed to downplay the seriousness of the conduct engaged in. There were not strong submissions over the level of intentional or deliberateness of the conduct. There was no strong submissions made about the engagement of senior management in this conduct, and there were not strong submissions made about the terrible compliance record that Origin has. The court was not apprised of all the relevant factors that it should have been apprised of to work out whether this penalty was adequate. And that's reflected in the judgment, which simply does not discuss so many key factors which penalty decisions
are expected to discuss. So I think the court wasn't given them much opportunity to reject the settlement, but had they been given all the relevant information, I think that there would have been no option but to reject the settlement. The final question is, should Origin remain an authorised electricity retailer? Well, the question here is, what do you have to do to lose your accreditation as a retailer? It's hard to believe that you could breach the relevant retail laws and rules on as many occasions as Origin has and somehow remain a fit and proper person. Obviously, it's a very big deal to withdraw the authorisation of such a large player as Origin as an authorised retailer. But if the law has any meaning at all, it has to be applied in circumstances where a company is continuing to engage in such terrible conduct and simply paying very small fines to put it behind them. So I'd say that if AER is serious about its obligations to only authorise fit and proper people to hold an energy electricity retail licence, that it should be taking steps to remove Origin's authorisation immediately. So that's all I had. I just find that these regulators are selling cases short that should be pursued with a lot more vigour. There's no reason to be cutting Origin Energy any slack for its poor behaviour, and a $17 million fine is just not even in the ballpark here. I hate to think that the legal team for Origin went out and had a big celebration after being fined $17 million for this conduct, but I'm sure they probably did. If you have any questions, feel free to give us a call or drop us an email. Bye-bye.